Commentary. Ek broken bodysuit. Ek missing wallet. Or ek 7-Eleven ka soda can. Yi koi comedy movie nai. Baki ek real life legal nightmare high. AAJ hum dekrai hain ek ACK shahan ek bad day. Ki waja esi ek mahila 20 sol. Ki jail face kara hi high. Ki yi waki ek galat femi tia for robbery. Chaley breakdown cardi hain.
So originally when I took the coke out of the store, he didn't call the police. He just told me to leave. But just so I could show good faith that I wasn't trying to steal the coke, I was just having a messed up day. I came back in there so I can pay for it, and that's when I had caught a retaliation.
Saw on video that got caught.
And they can't talk about that.
But how can they even talk about what she told them? Because I'm not able to impeach any of these witnesses if I don't have all of their statements that the state has. Tons of impeachment in it that I can use against Sinani, that I can use against.
So why is everybody waiting till the last minute to talk about a first statement? I do not find it hard to believe that these specific attorneys didn't know someone else was being prosecuted.
Can I call Uber? I can go home and get them, babe. I mean, sir, Your Honor.
Commentary. 2 SE 20 Saul Key Jail. Just for a coke? Judge Jahan Point Clear Kara he hain. Jabbot robbery. Kiati high. Toe item key mat nahi deki jadi. Balky was scuffle. Yajagda deka jada high Joe Corey Kuwakwa. Defendant claim Kara he high. Kuwa crypto investor high. Or surf wallable guy T. Apko kia lagda high. Kia ye story has him hora he high.
Follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
All right. After reviewing State's Exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty. The court will defer finding the guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Please.
All right. Anything you wish to say on behalf of your client?
Just asking to follow the plea bargain, Judge. In addition, if the court would consider probating all unfortunately defined due to indigency.
All right. When's the last time you had employment?
Been a couple of years, but I work for myself.
When you say you work for yourself, what do you mean? What do you do?
Investments. Make investments in the stock market and crypto.
All right. So then why were you at the location taking items from 7-Eleven?
It didn't quite happen that way, Your Honor. I had court that very same day. My bodysuit had broken and they had rescheduled my court date that specific day. McKinney explained to me that I couldn't walk around with my bodysuit like that, so he sent me home with the paperwork. When I got home, well, not home, but I got to the San Antonio Dodge dealership where my spouse works. They called me and told me I had a warrant out for my arrest. And so I was sitting at the McDonald's a couple of doors down while he finished up working. I was stressed out because I was trying to figure out, like, how did I have a warrant out for my arrest when I was already at the court for the court hearing? So I had to call the court. They gave me the runaround. I had to get rescheduled. They rescheduled me for the following day. And so I ended up walking over to the 7-Eleven, Your Honor, and I ended up grabbing a Coca-Cola, and I left my wallet at the McDonald's that was next door. I expressed to the manager that I was going to be right back, and he, like, assaulted me as I told him I was going to come back. And me and him got into a scuffle. I didn't steal anything, Your Honor. And so I ended up hitting him after he assaulted me. There was a guy in the way, and they broke us up. Now the retaliation charge came in because I came back with my wallet to show him, like, hey, I don't need to steal anything. I was just having a bad day because I had a warrant out for my arrest the same day I had went to court. And so he ended up calling the cops on me because we had already gotten into a scuffle.
All right. So the police report is saying that you left the store without paying for the merchandise that you took.
No, Your Honor. I got right outside. We got really right in it. We were at the door. I didn't leave the store with the.
Well, I mean, once you pass points of sale, so the register is here. If you pass that register without paying for it, that's passing the point of sale. So that's why you're charged with robbery. So do you want the court to accept this plea or do you want a jury trial?
My only concern, Your Honor, is I've been sitting in jail for 4 months. And I want to get out.
Commentary. Yahan situation serious ho guy high. Hamari defendant for Mahinesi jail main high or Sir Bahana County. Kalia plea deal accept Karn KO tire high. Judge Yahan stand lura he hain. When Nai Chadi Kakoi surf jail as in the county. Kalia Gunika bull care. Ye ek classic legal catch. 22 high. Fight for innocence and stay in jail, or admit guilt and go home.
So
No, here's the thing. I don't want to accept any pleas because somebody wants to get out of jail. Your attorney can always file a motion for a bond reduction. I will hear it. What I can tell you though is with the way the new laws are, if it's a violent offense, you're not eligible for a PR bond, so that's off the table. So it's completely up to you. Yeah, what I can tell you is what I've read, the stipulations. When that is entered, that means the reason why they call it the waiver and stipulation to evidence is because you're stipulating that everything is in there that is true and correct. And you're stipulating that if the witnesses were to come in and testify, they will say exactly what's in the police report to meet the elements of robbery.
I'm okay with that, Your Honor, because everything's on camera.
Well, no, I mean, it's up to you. If you want a jury trial, then we'll set it for jury trial. Do you need to discuss with your,
Set for trial in 2 weeks.
well, I don't know if it's going to make it in 2 weeks because we have,
We'll try.
the reason why I say that is because we have murder trials and capital murders that are set, that are before this case.
Sure.
And this case, all right, because this one is alleged to have been committed on or about June 16th, 2025. So there are cases that are older than that that will be before her. So is she withdrawing her plea?
Okay.
Yes, Your Honor.
All right. So if you'll speak with Ms. Ferguson and we'll set it for trial.
Sounds good.
Norma, if you'll give them a jury trial date, please. All right. And she wants a jury trial, correct?
Judge, we've turned in plea paperwork. She would like to take a plea.
All right. The court is calling 2025 CR 010958 State versus Kenora Adams. Could I have the parties announced for the record?
Espinoza for the state.
And Kelly Piddle for Nora Adams.
And are you Miss Adams?
Yes.
All right. You've previously been sworn in. And you were actually here on October 14th, 2025. There was a request to withdraw your plea and you wanted a jury trial.
Yeah.
All right. And are you asking now to enter into a plea bargain agreement with the state?
Yes.
All right, counsel, have you received all discovery? Did you review it with your client?
Yes.
Court will find that the state is in compliance with discovery. Probation, this is an application. All right, after reviewing state's exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty. Court will defer finding of guilt as you apply for deferred adjudication. Are you proceeding with sentencing?
Yes.
Anything you wish to say on behalf of your client?
Just asking for the burden.
All right, Miss Adams, they're requesting a referral to Center for Healthcare Services. Have you ever been diagnosed in the past?
I've been diagnosed with depression through the military,
Okay.
and anxiety, and I just recently had a baby, so postpartum.
Okay. All right. So what branch did you serve in the military?
Mhm.
Okay. I'm always wondering with the Navy, if you're on a submarine, I don't know if I'd be able to do that. So how long were you in the Navy?
7 years.
Okay. And do you have family support here?
No.
Right. Where is your family? Which state?
Illinois.
Do you want to transfer back to Illinois? Okay. No, if you want to transfer back to Illinois, we can do that. So are you 100% sure that's what you want to do?
It's up in the air. I have a house in Texas that I'm still trying to figure to.
Okay. All right. So this is what we're going to do. Ms. Abrams, can you see if Veterans Treatment Court is down here? All right. So what we're going to do is we're going to get Veterans Treatment Court. Not necessarily going to place you in Veterans Treatment Court if you don't want it. But if for some reason you're not able to be accepted into that program, they'll be able to give you different type of programs for outreach.
Is this an offense that qualifies? That's why I didn't.
Oh,
It did. I wasn't sure that. Okay.
they do a lot on case by case basis.
Okay.
All right. So do you have any help at home with the baby or anything?
So I'm dealing with a CPS case that is permanent. to kind of mitigate some of the symptoms that I have, like with my anxiety and depression, I smoke marijuana. And so I kind of got into trouble with that because I ended up having my daughter at home 7 months ago, and they made me go to the hospital. And one of the questions that they asked was, could I smoke marijuana? I expressed to them yes. I had been working on a medical marijuana card prior to me being arrested, but I did get my medical marijuana card, so that's why I wanted to make sure, like during the probation, would that be an issue? Because I do have my medical marijuana card.
No, just make sure that you give that to your probation officer, so that won't be an issue, and your attorney can help you get that to him. All right. All right. So does she have any type of priors or no?
I don't believe she has any criminal history, Judge.
No criminal history?
No.
Right. So it seems like on this day, everything just converged.
It was a bad day, Judge. She found out she had a warrant for an unrelated case due to the leaving court early, is my understanding. So she was having difficulty at that time.
Which court was that? They said she left.
7 or 13. One of the two family violence courts. And she didn't have her wallet. She took a can of Coke. Her wallet was outside. So unfortunately, she took the can of Coke out, and then she had the money to pay for it. And then that's what happened.
Well, I was just having a bad day. My bodysuit had broken. Officer Wilson, he's a nice officer here, he came and said, Ms. Adams, you can't walk around like that. He gave me the paperwork to go home. So after I went home, I didn't go home, I had to go sit at a McDonald's while I was with my spouse waiting because we only had one vehicle. After that, I walked over to the 7-Eleven and grabbed me a Coke. I realized I left my wallet. But before all of that happened, they called me and said I had a warrant out for my arrest because I only came in one court. Okay. And so I was stressed out that day. I'm like, man, I've been dealing with these bail bondsmen. I've been communicating with you guys. I got arrested when it was the other way around, but grabbed the Coke, me and him get into a physical altercation. He said, I was trying to steal the Coke. I explained to him, my wallet is at the McDonald's next door. Can I please grab it? He grabbed the Coke. I went back to McDonald's, grabbed my wallet, came back, tried to pay for the Coke. He told me to get the F out the door. And I started knocking over a couple pieces of candy, and that's when he called the cops and they came and arrested me. So originally when I took the Coke out of the store, he didn't call the police, he just told me to leave. But just so I could show good faith that I wasn't trying to steal the Coke, I was just having a messed up day. I came back in there, so I can pay for it, and that's when I had called a retaliation.
Okay. All right. This is what the court is going to do. The court is going to sentence you to 2 years deferred adjudication. There's a $1,000 fine that will be probated. Let's do a referral to BTC. Again, it's for them to talk to you. If you decide that's not a program that will be helpful to you, it'll be completely up to your decision. If they want to accept you, just listen and you can talk to them with your attorney and see if that will be a good fit for you. But I think if you're accepted, it will be a good program because one, they'll be able to help you perhaps if you want to ultimately transfer to and help you with any other issues that are happening. So referral to VTC, CPS compliance, field visits 1 time per month until further notice. This is to run concurrent with 2025 PF 40428, which is also 2025 CC 014365. Taking into consideration 2025 CR 010957, 150 hours of community service restitution. I'm going to order parenting classes. Once parenting classes are completed, the community service hours will be deemed satisfied. If they're requiring you to do parenting classes on the CPS side, that will count for the parenting classes that I'm requesting. MIC evaluation out of custody. Are you receiving any help through Center for Healthcare Services or anyone?
In regards to services, what do you mean?
Mental health.
Any mental health services?
The VA.
All right. So there's to be continued mental health treatment through the VA. And I'm sorry, with the community service hours, once parenting classes are completed, 50 hours will be deemed satisfied. The remaining 100 hours will be deemed satisfied once anger management is completed. And there's to be no contact with 7-Eleven convenience stores. So you're going to have to go to somewhere other than 7-Eleven. Proof of employment within 60 days. No employment as a home health care provider or with minors. Is there anything else?
And you did say regular court.
Of course I did not, but I appreciate you covering for me. There's to be regular reporting by Zoom or in person and regular random UAs, or she can do a patch. Your attorney will explain to you what the patch is. And she does have, she says, a marijuana card. So she'll be giving that to you. Is there anything else? Is there anything else you need from the court in order to be successful?
Can't think of anything at this time.
All
But
right.
I will say this, Judge.
Yes.
While I have been on house arrest, some of the girls, while I was incarcerated, they told me that you had a YouTube channel, so I got an opportunity to watch a couple of your videos.
Okay. So, and I hope that means that this wasn't, I always tell people, court, yes, can be a scary place, but hopefully people will become educated about what happens in court, how to dress appropriately, how to respond appropriately. So you're currently on GPS?
Yes.
And is that through this court?
Yes, sir.
All right, State, do you have any objection to removal of GPS? All right, and remove GPS. All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
That's the name.
Yes.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes.
All right, we can go off the record. So here's the thing. In this court, to be successful on probation, communication is key. If there's an issue, call your probation, let them know about it. If you feel they're not addressing it, you can always come back here and address it with me, all right? All right, good luck. And somebody from Veterans Treatment Court will come down and speak with her.
We're going to go handle county court 2 and we'll be right back up.
All right.
Commentary. Bomb dropped. Defense lawyer. Eniek bada loophole pack at High. Ek mysterious officer. Ek AC bodycam video Joe Sai Wakpar Banho guy. Or police report main gaps. Drama to Shira Hua Hai Kyunki wa officer Kajishi. Or case main prosecute Ho Raha Hai. Kia ye surf ek coincidence high for dirty tactics?
I'm thinking it's one of them. We've subpoenaed them. We can talk to them about it. This morning, I asked for the officers that I thought it was, Ms. Caballero.
Officer Caballero.
Asked her, because she wrote the statement that she's the one that met me. So I said, here, will you have her review this 1 minute, 30-second body cam, just so we can.
So what's the issue?
Issue is, she says, well, that's not me. It's these, I think it's these 2 other guys who were mentioned nowhere in the reports. And in the video, she starts making a statement about what happened to those officers, and then it cuts off.
Mhm.
So I don't know who those officers are. I don't know what that statement was.
Mhm.
There's no way I can properly impeach her.
Well,
second,
that
third,
person, well, the statement is not going to
There's
come in until we have a hearing on it.
My issue is that they've got officers they want to bring who heard a second version, a third version, a fourth version. They're saying that's not us that heard that first version that you saw on video that got cut off.
And they can't talk about that.
But how can they even talk about what she told them? Because I'm not able to impeach any of these witnesses if I don't have all of their statements that the state has. And I don't have the same knowledge that the police department has. Since they took these statements, that first statement might have tons of impeachment in it that I can use against Zanani, that I can use against.
So why is everybody waiting till the last minute to talk about a first statement?
There, to the state's knowledge, there are no statements that have not been disclosed to defense. Everything has been documented in the report and has been provided to defense.
So here's my question. Has the first statement been provided?
Yes.
So is the only issue that there needs to be an officer?
Hold on. What it is, Your Honor, is that the statement was stopped in the middle of the the body cam video, the statement's done. So we were thinking, because the impression that we got, it was from this one officer who was going to be testifying. So when we go to question her and we were asking her questions, it's basically saying, oh, that's not my body camera. That wasn't me. I don't know what happened at that point.
She didn't know what that statement.
So she doesn't know anything about that statement. So, and the statements have been changing throughout. So we want to see how far the statements have changed from statement number 1 to statement number 2 to statement number 3. If we're just finding out today that that statement number 1 wasn't even taken by the officers who we believed it to be, we can't properly impeach. If they can identify who that officer is, then we can bring them up and testify, well, what is it that she told you in statement number 1? But we can't even do that because they've not been identified to us. There's no supplemental reports by this person. And as you well know, in investigative processes, any officer that has any contact with a complaining witness and that complaining witness is making statements should, under proper investigatory standards, make a supplemental report so that we can know what's going on. We can't even say that today. So as far as the court's question as to why are we just finding this out right now, we just found out right now. This is not any bad conduct, and I'm not trying to impute any bad conduct on the DA at this point, but my point being is that this is something that should have been brought to our knowledge, and just hiding the ball and saying, well, we didn't think about it, we didn't know about it, that's insufficient. That's denying the client due process.
Here's my question. 1, how many statements were made?
At least 3.
One statement that they made initially to the officer. What they're referring to, this body cam that they have, there is no audio on this body cam itself. It cuts off. It's like a minute and something long. It's very short. If Your Honor would like to watch it, see there is no audio on it. Additionally, the statements were, as I was saying, to Officer Caballero, who is here present to testify. If there's follow-up done by the assigned detective, that was good.
So this is my question, and I want everybody to answer the questions that are being asked. First, is this a statement involving the complainant?
Yes.
All right. So how many statements is the complainant having is attributed to the complainant?
Okay, are we referring to different times when the statement was made?
Just a total. Did this all happen in one sequence?
Of course not.
All right. So here's the thing. I need one person at a time. And this is what I want to remind everybody. I cannot make a proper ruling if everybody wants to converse over each other. This is the information I need, and this is the information I want. And then you can all do your arguments afterwards. So the first statement, and I'll just call it first statement, and that was by the complainant. Who is the officer who took the first statement? All right, I'm gonna have y'all step back. Y'all discuss whatever y'all want to discuss, then you come back. But the jury is coming in like 5 minutes. And if y'all have not finished discussing it, then that means that you all don't want me to make a ruling on anything.
I want you to make it. We'll get it. Okay, we're ready.
So,
answer your question.
All right, so this is my question. Listen to my question, please only answer my question.
Yes, Your Honor.
So the initial statement of the complainant, what medium was this done in?
On emergency 911 call.
Okay, non-emergency 911 call.
Emergency, yes.
All right. That's the first statement.
First time she tries to make a statement about this incident.
All right. And then the second statement?
It's when she goes to the police station and meets with Officer Caballero.
No, that's not correct. The second statement was made at the station to some mysterious police officer who had the body camera. And the body camera, as she starts to talk, it goes off. Now, the questions that we have is, what did she tell that officer, and why? And if we had that officer, to ask the officer, why did you feel the need to turn off your body cam?
Is there a statement?
So what is in their discovery, the video that they have is assigned to an Officer Kennedy. Reading on his supplement, if they disagree, to me, it appears he is their live police department's version of like a UEDI. It's the person that essentially took the photographs, attached them to the report. That's what his supplement looks like it reads. I mean, yes, it looks like when he was taking photographs, statements were given to him, but essentially his purpose of coming to the station was for that. And there may have been statements given to him while he's taking photographs. Is the only body cam exists that is this one that they have, where as soon as potentially audio comes about, it cuts.
And
Okay.
the point that we're making with that particular statement, Your Honor, is that through their own witness and evidence we got so far from discovery, is that there was another officer there, and the officer Kennedy saying that wasn't my body camera. That mysterious person.
We thought it was going to be Officer Kennedy. He's the only other person. Officer Caballero, when I asked her, well, why don't you take a look at this video before Kennedy gets here? She says that's not Kennedy.
Stop. Let me ask you this. Are these officers here?
Yes.
Officer Caballero and Detective Jimenez are here.
All right, bring
Kennedy's
them down. Right. So both the defense and the state are going to speak with you briefly in the back. There is an issue concerning a body cam video and audio. And so there's been some discrepancy over who that might have been. So maybe you all will be able to clear that up for the defense and the state if there's any type of discrepancy. So that's the only thing they're going to ask you about, because now is not the time for people to do direct examination and cross-examination. It's just for them to discover an issue with a body cam. So supposedly, from what they're telling me, there was a body cam with the complainant in this case.
yes.
The audio was cut off, and there's some confusion about whose body cam that belonged to. So you all may be able to clear that up for us. So if you all will talk to them in the, we have a waiting room there. If you'll talk to them, and maybe we can discover who that is, and then we'll proceed with trial. All right, thank you guys so much. You're welcome. Okay, let me just do this first. All right, we're gonna go on the record on 2024 CR 3498, State versus Duran Evans. Could I have parties announced for the record?
Daniel Diego Sanchez for the state.
Sid Greehey for Mr. Evans.
Yes. So where are we?
So we discussed this with the two witnesses, the two officers in the back. The female officer gave two names. She thought that it might be a Corporal Reese or an Officer Brian Smith. The gentleman officer said that he thinks it sounds like Officer Kennedy. We just found out right now that Officer Kennedy was charged with aggravated assault by a public servant in this courthouse, being prosecuted by this district attorney's office, which we were not made aware of until just right now. He apparently pled out of the 226 on the 1st, which was Monday. He's sentenced for a PSI on the 28th of January. We're just finding this out.
You know, as far as our ethical obligation, when it comes to this, there's no obligation until a conviction of the officer has been determined, and his conviction will come, it looks like, in January, and at which point that would have been the state's responsibility to this ethical disclosure.
But shouldn't they have been made aware in the spirit of the law and what they should be told? That your witness.
Yes, and as soon as we became aware of it, it was disclosed.
I find it hard to believe that this district attorney's office is not aware of a person that they're prosecuting in the courtroom directly underneath this one.
It wasn't disclosed till 30 seconds.
All right, so here's the thing. Number one,
We still don't know who the officer was on the body cam.
just 1 second. So number one,
Commentary. Law 101. Actual versus constructive knowledge. Judge Kietri Hain Kabale High Prosecutors Ko Pada Nai the Uncle Witness Cadet Criminal High. Ani Pada Hona Cheda Chunky wa Izai Building Main Trial Par High. Courtroom Main Frustration. Level 100 Par High. Or Jury Bahar Wait Karahi High. Yikes Hof Esi Nikalta Jaraha High.
I do not find it hard to believe that these specific attorneys didn't know someone else was being prosecuted. Now, are they supposed to have constructive knowledge? That's completely different. But as far as them having actual knowledge that he was charged with an offense and that it is in this courthouse, necessarily they wouldn't have an actual knowledge of that. And how many prosecutors, when you're running criminal history, you actually run the criminal history of officers? That's usually never done. So I understand that constructively they should have known, or constructively they do know, but they didn't have actual knowledge. Did you have actual knowledge?
Did not.
All right. So he doesn't have actual knowledge, but he has constructive knowledge.
Your Honor.
All right. All right. So someone needs to get on the phone, and whoever those officers are saying they believe it's this person or that person, someone needs to actually call or have them call to find out who this person is. Does everyone understand?
Yes, sir.
All right. So make that happen. And then we're off the record. And Mr. White?
Yes, Judge.
All right. Who is the prosecutor who can do his paperwork? Is that Ashley? Is she able to do?
It can belong to any other officer other than Officer Kennedy. Still trying to confirm it through superiors over at the Live Oak Police Department. But no information has been provided to us that would lead us to believe that it is anyone else but Officer Kennedy.
All right. So here's my other thing. So is Officer Kennedy subpoenaed to testify in this case?
He was not subpoenaed by the state. He was not, the witness state was planning on calling.
I've issued a subpoena
if needed for him.
All right. So the state is going to want him to be here. So y'all will need to contact Mr. Kennedy's attorney. So I'm going to excuse the jury. They're going to be back here tomorrow, and you all need to be here by 10, and you need to have all the information, be ready to proceed.
Sure.
Thank you.
All right. Thank you.
Commentary. About personal Hogai High. Defense lawyer, any prosecutor, could call off grievance file karn ki dankidi high. Judge isi chilling effect ki atri hain. Ek chodi si kori ka case of lawyers ki ego warband chuka high. Ki system ka failure high ysurf ek aggressive defense. Next update Kalia subscribe karnamat bolna.
Prosecutor for pursuing this case. Court has some concerns with that. First and foremost, that posture in and of itself can have a chilling effect, not only on just proceedings and may be an attempt to interfere in these proceedings, which may in and of itself constitute a grievable offense, but also that this court, if that is indeed the allegation, would not proceed with a hearing that would require someone to then commit a grievable offense. And Ms. Hughes also disclosed to the court that she, in essence, went up her chain of command to seek their advice as to what she should do. It was ultimately said, I think, at one point to certainly bring it to the court's attention, which I think is appropriate since it's under. Mr. Bennett, I will ask you whether or not you believe, in this case, that the people in proceeding are committing a grievable offense. And if so, for you to state on the record what that offense is.
My concern.
I'm not asking for your concern. I'm asking for you have made an accusation that know what?
I don't believe that they're committing a grievable offense.
Do you believe that in starting this exam that they would be committing a grievable offense?
No.
Was that said to the prosecutor?
That was said, I don't believe it was said in the manner that was described at the bench, but certainly.
Then tell me how it was said.
Well, there were two things. One, at the bench, do you want me to ignore the one you didn't disclose?
Tell me how it was said.
What I said is that I believe that if the state were to go forward, that it would be grievable because I believe that the prosecutor is not following through on their ethical obligations under the Michigan Rules of Professional Conduct.
Which ethical obligation are they not following for?
The two that I am concerned about are, one is determining what the actual facts are, and the two is prosecuting somebody who may in fact be actually innocent. What I did was I had offered Ms. Hughes, if she felt that it was appropriate, if she wanted to discuss the recanted note with the alleged victim, I said, why don't we could just adjourn this out and you can talk to her and decide how to go forward. So my only concern is that they didn't make contact with the alleged victim, who now has a different story, but I no longer believe that's a problem.
Does that, even as you describe it, amount to something that is grievable?
It doesn't.
And why was it said?
Because at the time I believed that it was grievous.
What changed?
Quite honestly, what changed is I wasn't aware at the time that they had the lay witness here. And so the presence of the lay witnesses, I think, eliminates all of the issues I had with the police providing the testimony that's admissible here, but not in trial.
Ms. Hughes.
I absolutely intend on proceeding pursuant to MCL 76827C. I have made no statements to Mr. Bennett about Ms. Potter being present. But I don't think it is, because Ms. Potter is not present.
Explain to me, Mr. Bennett, how that makes a difference. Because quite frankly, I think your accusation is against the prosecutor amounts to your attempt to obstruct these proceedings. So explain to me, which in and of itself would be grievable, counsel. So explain to me what happened now that you know that they're there, how that changed the whole mindset.
The proceeding with statements that would exclusively be inadmissible at trial and going forward on those. These are confrontation clause issues.
There's a statute which covers that.
I understand that, Your Honor. My concern was it goes to circuit court on those statements, and now they can't proceed to trial. Because at that point, confrontation is going to attach at trial.
So why would that be grievable? If they proceed pursuant to a statute promulgated in the state, as well as a court rule, which covers that, why would that be grievable at any point?
My concern was not determining the facts of the case that they're going to present evidence in today.
If they believe those facts that, but for a hearsay objection, would come in, that not at all goes to their determination of the facts. They may believe that to be the case.
I understand.
So how would that even come into play? Mr. Bennett, how does that even come into play?
I explained what my position is. I don't know what else to say.
Okay, let me just say this. I don't care if somebody's on the defense side. I don't care if somebody's on the prosecution side. It doesn't matter to me, especially between counsel. No one is ever going to come into this courtroom and be intimidated in some way by some threat to their profession, particularly in proceeding with what is their obligation. It is Ms. Hughes's obligation to bring this case. It is your obligation to defend your client. She can't make threats to you to try to prevent you from proceeding to defend your client, or to do nothing if your client wishes that for you to do that as the defendant. This behavior, Mr. Bennett, is inexcusable in this court's mind. Absolutely inexcusable. And quite frankly, sanctionable, because you can't try to make somebody not do something by, quite frankly, as I'm listening to your explanation, are just absolutely unequivocally false threats to their livelihood.
I don't believe that's what I was doing.
What do you think you were doing?
Trying to bring to Ms. Hughes' attention an issue that may or may not exist. She interpreted it as a threat, which I understand.
I'm going to grieve your boss and you.
I did not.
If you start this exam, she's supposed to take that as something that should be brought to her attention as opposed to a threat?
We continued our discussion a second time where I was explaining where I was coming from. I did not say what I said in a very artful way. So
you threatened a grievance for her proceeding. Am I wrong in that?
I didn't consider that I threatened it. I was trying to bring an issue forward. She took this threat.
She took it as a threat. What was she supposed to take it as?
She took it how she took it. I mean, it was a mistake on my part. I acknowledge that.
You're trying to tell this court that you didn't intend to threaten her boss and ultimately her? Is that what you're telling me, Mr. Bennett?
I was trying to bring the nature of what I saw as a potential issue. I unfortunately started it.
The issue being what? Their use of evidence pursuant to the court rule, which is why we have these hearings, why you have the ability to object, and then this court would have to rule?
I felt this case was different because this is not a situation where, this is a situation where the alleged victim is given another detailed statement as to what happened.
And so what makes that different?
The duty to investigate the facts.
How do you know they haven't?
Besides her telling me that they haven't, I don't know.
I don't know who her is, but I've never told him the information. I've never told him about the many contacts that she's had with my office. I've never told him about, he's put on the record that she's been appearing at the hearings. Your Honor, she's been at hearings that Your Honor has presided over. The letter that was turned over to the police department was then turned over to the defense. And frankly, he has never asked me. He just came forward with, I'm going to grieve Ellie Sabat.
Mr. Bennett, I am very concerned. What was your intent on saying that?
I intend in this.
You know, I'm going to stop you right now because I'm going to tell you something. You need to be real careful because I may have to consider grieving you.
I understand that, Your Honor.
And I don't think you want that.
I certainly don't want that.
So what I'm going to do is I'm going to take another about 10-minute break. And I'm going to come out and ask for your explanation before I decide on anything that I would do. But I will let you know, Mr. Bennett, with regard to what I've heard of the conduct here, you are walking on real thin ice, not just with me, but with your ticket to practice. Court's in recess.
All rise.
Back on the record in the case of the people, State of Michigan versus Whitley, counsel is present as well as the defendant. Is there anything else regarding this issue that either side would like to say?
Your Honor, I'm going to self-report the violation under Michigan Rule of Professional Conduct 8.3 subsection A. I agree that I gave the inappropriate message to the prosecutor. I apologize for doing that. I feel obligated to report myself.
We will see if that happens because the court hasn't made a decision as to whether or not the court should report you. Mr. Bennett, I am going to tell you in all the years I've been here, counsel, and even when I was down in the trenches, counsels say things to each other, maybe not meaningful necessarily. They'll say things out of anger to each other. I don't know why you would even think it would be within the bounds of anything decent to make that kind of threat. And I call it a threat. That's precisely what you were doing. And I have to make a decision now knowing it as to whether or not I should do it. And I will make that decision. Ms. Hughes, and I'm going to apologize on behalf of the court for having to do this, but I think it's necessary given this turn of events. Would your lay witness, as well as I guess the officers, would they be available on July 1st at 10?
Is it at all possible to have the lay witness testify? It would be to identification. And I would.
As to identification of
the defendant. So it's very brief, and I don't want to have to bring the lay person back.
Understand. Mr. Bennett.
I would stipulate to the identification.
So you're stipulating that the person that is sitting beside you is James Whitley and that he was in a relationship with Jennifer Potter on April 27th, 2024.
Yes.
Thank you.
Will that satisfy what that witness would testify to?
Yes.
Very good. Thank you.
What was the date? I apologize.
I am going to adjourn this, if it will work for everybody, to July 1st at 10 a.m. That is my only.
July 1st at 10 a.m.
Good afternoon, Assistant Public Defender Lauren Perny on behalf of Ms. Burnett. Ms. Burnett, please state your name for the record.
Shalisa Burnett.
Good afternoon. All right.
Ms. Burnett does have a valid license. She doesn't have it
Hold
on her.
Now,
Hold on. She's coming up here. I got a valid license. I don't know.
yeah,
I got to check
the whole
myself.
permit to everything.
Hold on.
She did say she got it about 2 days ago.
Yeah, but I was so geeked to come to court. I thought I had my wallet, everything in my purse, but I don't. But I do have my license. They are legal.
Hold it. You came to court, you don't have your license? Did you drive?
I'm not a good liar, so yes, sir, I did. But I'm legal though.
No, you didn't. I didn't hear that.
Okay, you did.
Nobody heard that.
You didn't. Y'all didn't hear that.
Oh, that guy back there did. No, I'm kidding. All right.
Stop playing, because I know him. No, but I'm legal though, for real.
Yeah, no. Just, who'd you bring with you?
My daughter and my son-in-law.
Do they have licenses?
No. Oh, we can Uber this home and get them and come back.
No.
But I was not going to miss Kurt.
Go get your license. Just, that's why you went through this whole thing.
I know,
So
but see, they told me I was supposed to come at 9 and I came, and then they told me I had to come back at 12.
And neither time did you have your license with you?
Yeah, the first time I did.
Oh, okay.
And I thought everything was in, I was excited.
You were excited about what?
Showing you my L's, and I ain't even got them.
You were all excited to show your license and you forgot it. It's a shame.
It's the truth.
You believe her. No, and nobody knows.
I promise you. I already seen you, so I already know you can't be playing with you.
What does that mean?
Because I'm just not from here. So this is my first time. So I was really excited, damn. I can't even be
You're gonna get a license mic drop. Yeah, they ain't got a license.
No, I just have them on me.
Listen.
Can I call Uber? I can go home and get them, babe. I mean, sir, Your Honor.
Maybe I go and get them.
No,
it's okay.
I'm so sorry.
I take no offense. I've been called a whole lot of things.
I promise you.
Not a bad thing. My book. Listen, I have your driving record. So I already know you have a valid license. So why did I say that? Because you wouldn't stop talking. You just kept talking.
Well, I got 9 insurance,
You
so
just kept talking, and I didn't have time to get it in.
I'm really excited though.
Me too. She got a license. So you live over in Ipsy?
Yeah. Yes, sir.
I gotta stay out of there because she driving. Ain't no telling what's gonna happen. All right.
So they say I drive like Miss Daisy, so I ain't even worried about it.
Okay. What are we doing?
No, Your Honor.
I know we all forgot.
We are here for a purpose, I guess. She does have a valid license, so she would like to accept the prosecutor's offer to admit responsibility of double parking today.
Your Honor, I move that count 2 double parking. If you accept the admission, move to dismiss the misdemeanor.
Burnett, she gonna blow this. She gonna mess this up. Just concentrate, focus. All right, so we can try to get through this. Do you admit responsibility that on November 4th, 2024, at the location of Ellsworth Road in Pittsfield Township, Washtenaw County, State of Michigan, that you double parked a motor vehicle?
Yes, sir.
Thank you. Court will accept that admission to count 2. Count 1 is dismissed. Fines and costs of $180. When can you get that paid?
Next Friday.
Next Friday? You can
Yes,
get
sir.
it done by the 28th?
Yes, sir.
I don't know. All right, I'm going to give you to February 28th, 2025. All right, pay it by then. You take care, and when you're out there driving now legally, drive safely, please.
Okay, thank you.
Hey, take an Uber. She loaded.
Probation officer is scheduled at 8 a.m. on December 18th. How do you plead?
Guilty.
to the allegation you failed to attend individual therapy at the guidance center is scheduled on 12/12. How do you plead?
Guilty.
And then we're doing a not, and to the allegation you failed to attend your individual therapy on 12/13. How do you plead?
Not guilty.
All right. All right, I'm going to accept the 2 guilty pleas as knowing and voluntarily given. All right. So I saw you, Abigail, on the 10th. And on the 10th, I let you turn yourself in for a day next door. I let you turn yourself in because I care more about your job than you do. So then, the day after that, I do this on Tuesday. You miss your guidance, your therapy appointment on Thursday, and then you miss your appointment with Kara yesterday. And it's like I don't know what you were thinking. Abigail, we've had trouble with you since you came in. It's not use violations. Oh, are you shocked by this? Are you surprised? Well, you should not be. You have consistently, if I count your violations, like I know that we're on number 7, but if you look at them, number 7's 3. Number 6 was 1, 2, 3, 4, right? I mean, it's like Kara's bunching them because it makes sense when you have that many violations in a short period of time. But you're consistently, you think this is Abigail's treatment court, and it's not. Yes, you do. It's a 23rd District Court treatment court program, and you're not special. You're not special in this program. Everyone else has to show up, and they have to do what they have to do to survive, but not Abigail. Abigail can cancel her appointments as she sees fit. She can miss things, and it's a consistent pattern. And the response that we always get from you is like, well, I have a job. Well, your recovery is more important than your job. Because if you're sitting in Wayne County Jail, quite frankly, Abigail, on this, it should have been charged as a 3rd, and you should have a felony right now. Because let's talk about your record for a minute. You've had 3 drunk drivings in how long?
Within a couple of years.
Right? When was your first one?
February of 2023.
Okay. When was your second one?
December last year.
Of 23?
Yes.
Okay. Oh my gosh. When was your 3rd?
April.
April of 24. 3 drunk drivings in a year? Less than a year? Am I bad at math?
Oh, just over a year.
Just over a year. 3 drunk drivings. How old are you?
23.
Your last drunk driving, Abigail, you drove the wrong way on which freeway? Which one?
75.
75, we are miles out of Detroit. One of the busiest freeways in the state of Michigan, and one of the busiest areas in the state of Michigan. And you drove the wrong way on the freeway. That's how drunk you were.
I understand, Your Honor.
Okay, well, we're going over it because I don't think you do. I genuinely do not think you understand. And then you wouldn't stop for the cops. And a cop had to tap your car to get you to stop and get you from killing someone else or killing yourself at 23 years old, your 3rd one in just over a year. And you got a gift. One, you got your life. You're not dead. You're not in prison for killing someone else, which is a miracle, going the wrong way on one of the busiest freeways, probably in the country. We're the Motor City, and you're driving the wrong way on one of the busiest freeways outside of Detroit. Then you get the benefit somehow of, instead of having a felony, you get the benefit of getting a misdemeanor for this. And in exchange, you have to do a treatment court program. That's the thing. And you should have been doing prison time. You should have been, or at least significant jail time. And you were given a gift and you have squandered it. I have watched you since you come into this program. You think you're better than the other women in the program. It's clear to me. You think that, well, I'm going to start sponsoring someone, and you have all this time for all of these other activities. You don't have time to show up and do the things you have to do to stay out of jail. And I've had it. You're about to get the wake-up call of your life, Abigail. I'm talking. I'm about to give you the wake-up call of your life, okay? Because have you ever been to Wayne County Jail?
No.
Okay, you're about to go in just about 3 minutes. But let me tell you something. I have been to Wayne County Jail. I've been to Wayne County Jail a lot. I was there when I was a defense attorney, and I was there when I was a prosecutor. And it is not a nice place. It is not a pleasant place. And me giving you a day next door is not teaching you anything. I need you to understand you are looking at months in jail. Months. And quite frankly, even at their new facility, probably one of the grossest jails I've ever been in. And with people who are sitting in jail, awaiting trial or sentencing on pretty significant crimes. And you'll probably think you're better than them. And you're not, Abigail, because that's where you should be. So you are getting the wake-up call of your life. You're going to sit down in the Wayne County Jail. What's your rec?
3 days.
5 days. You're doing 5 days in the Wayne County Jail. You got nothing else to do? Forget your job, forget everything else, Abigail. I want you to understand this. I want you to really reflect on the next 5 days. I want you to sit there and think, is that the life you want? Or do you want to comply? I'm talking. You can either comply with this program and get it together, or you can go do your 90. It makes no difference to me. I'd prefer you be here. I prefer you get the help you need, because whether you realize it or not, you have a problem and you belong in this program more than a lot of the other women that are here. Because what you have done on these 3 offenses is abysmal. It's terrifying. You're doing your 5 days at the Wayne County Jail. I'm writing no early release. You're gonna really reflect. You'll be out for Christmas. My gut tells me to give you 7, and I don't know that you deserve that yet. You're going in right now. You'll get out in 5 days. No early release.
I can't explain the...
No, I don't need it. I don't care what you want. Okay, go ahead, Al. Go ahead. Let's see if we can get you up to 7 days. Tell me what you got.
I mean, if it's not going to matter, it doesn't.
Does my face look like it's going to matter?
No, it really doesn't. I had a lot of really nice things to say about the program. I really appreciate being here. I understand that what I did is absolutely horrible. I feel awful about it every single day. I'm haunted by it, honestly.
You should be.
And I feel really, really grateful to be in this program and to have the opportunity to work towards a better life versus just incarceration. And I feel really grateful for treatment.
Well, show up and do the program or go sit in jail. That's your option.
I was throwing up all week. I haven't eaten in 6 days. That's why I missed on Wednesday.
Abigail, listen to me.
I'm going through an epilepsy diagnosis. I'm having seizures in my sleep. I slept through a therapy appointment, and I have a text from Josh that says any day that we need Zoom, we can use it. And then I showed up. And then he told me that we couldn't use it. It was a misunderstanding, miscommunication on his part or mine. I don't know, but I genuinely, I took everything into account the last time I was in front of you, and I took
and then you immediately missed another appointment and you're I'm done. I don't want to hear anything else. I'll mark your file medical. Enjoy your 5 days in the Wayne County Jail. When you come back, you can tell me whether you want to be here or whether you want to give your spot up for someone who's earned it.
There was a hearing date for the...
I don't care about the other violation. Dismiss it. All right, come on up. Miss Heiss, I need you real quick at the podium. I need to give you your appeal rights. All right, Ms. Heiss, I did not give you your appeal rights, and I want to make sure you know them. An appeal to circuit court may be taken within 21 days from the date of your sentence or as permitted pursuant to NCR 6.625 parent B. If the sentence includes incarceration, which it does, and you wish to file an appeal but are financially unable to retain a lawyer, the court will appoint a lawyer to represent you on your appeal if the request for a lawyer is made within 14 days of sentencing. Understood?
Yes.
Okay. Thank you, Ms. Heiss. You're all set. Can you please not make Ms. Heiss listen to that for too long?